Justice Mnyau. I am the presiding judge here in the KISII Law Courts. Today we had Judiciary Dialogue Day. This is a day that was set aside by the Judiciary to have a dialogue and to have a discussion with the public and with all stakeholders in the judicial sector. It is a day that has been long coming because we've not really had a forum where we can engage with the public. Many times we hear of the judiciary in the social media, the press, but we've not really had an opportunity to engage directly with the people who consume our services, or the public in general, and also putting together ourselves and other stakeholders and the public together so that we can have a dialogue and a discussion about how we conduct ourselves, to hear from the public whether they are satisfied with our services, to take in suggestions, and generally just to see how we can improve our services to the public. As you know, the judiciary is one of the three arms of government. The constitution, the sovereignty belongs to the people. The people can delegate their sovereignty to various institutions. One of these institutions is the judiciary, and the judiciary was formed in the constitution for purposes of resolving disputes within the community so that people have a place where they can have their issues resolved and to prevent a state of anarchy in the state. So the judiciary is a very, very important institution in maintaining peace, law and order in this country. Now within this dialogue, we of course took in a lot of views related to how we work. There were proposals on how we can better our services, and we also engaged the public to explain to them how we work, the challenges that we face. One of the challenges that the public need to know about is funding. We are severely underfunded as a judiciary. We would be happy to have an allocation of about 43 or so billion. But the current allocation that the judiciary gets is about 22 billion. That is just about a half of what the judiciary requires to operate optimally. And now, because of that lack of funding, we of course fall short in many areas. For example, we do not have a court of appeal that has a good number of judges. We just recently cancelled an advertisement for the employment of 11 Court of Appeal judges because of lack of funding. We also cancelled an advertisement for recruitment of 5 High Court judges because of funding. And of course now if we do not employ, then we fall short. And when we fall short, that means that cases take longer to be resolved, which does not augur well to the public. So one of the important things is that I've just mentioned, funding. The other thing that we need is to have public confidence in the judiciary. The judiciary requires the public to have confidence in it so that when they bring their cases, they know that their cases are going to be resolved fairly and squarely based on the facts and the evidence and the law as it stands. When we heard from the public, there was mention, there was talk of lack of confidence, but I want to assure Kenyans that the judiciary is actually a very strong institution. It is one of the institutions that we can confidently say works and executes its mandate as required by law. The public need to have confidence in this institution because it is a working institution despite the challenges that it faces. Cases are actually resolved and we endeavor to resolve them in time despite the limited resources that we have. We have a very robust appellate mechanism so that if a person is not satisfied with the decision of a court, they can escalate it to the Court of Appeal, to the appellate court, to the magistrates court, then to the High Court, or to the Environmental Land Court, the Employment and Labour Relations Court, and further to the Court of Appeal and even to the Supreme Court. So the public need to have that confidence that the institution is working, and it is actually working, and to have confidence in the system of appeal, the appellate system, so that if one is satisfied, they can appeal rather than castigate the judge or the judicial officer who's made a decision. The other matter that arose is corruption. There was mention of corruption. And I think that the judiciary has been unfairly targeted when it comes to corruption. We hear a lot of talk of corruption in the social media, in the newspaper, and in other media, in other forums. But I would think that these are unfair. It's an unfair criticism of the institution of the judiciary. For reason that if indeed there is corruption, this cannot be institutionalized. You cannot say that the judiciary is corrupt. The most you can say is that a particular individual within this institution is corrupt. And you cannot also just allege that a particular person is corrupt without presenting evidence. First even mentioning who that person is and presenting evidence to demonstrate that this particular individual is corrupt. It is very unfair to label the institution of the judiciary as corrupt when that is not the case. If indeed there is one or two individuals who are corrupt, then it is the mandate of the person who is claiming that this person is corrupt to take that individual to the necessary authorities. We have the Ethics and Anti-Corruption Commission, we have the DCI, we have all these institutions where you can take any complaints of corruption. Even within the judiciary, we have the Judiciary Ombudsman, and you have the Judicial Service Commission where you can present your complaints. So it is unfair, and I would really ask the public to desist from labeling the institution of the judiciary as corrupt when that is not the case. We have to have confidence in the institution, and I can guarantee you that this institution is not corrupt. This is an institution that works, that does its best to execute its mandates despite the challenges that I've just mentioned. And even us as judges and as judicial officers, we guarantee the public that we are going to execute our mandate as provided for in the Constitution. Here in KISII, we have done our best despite a very heavy workload. For example, in the High Court, we have about 1,000 pending civil cases, about 700 criminal cases. In the Magistrate Court, we are talking of about 6,000 pending cases. In the Land Court, we have about 700 pending cases. So indeed, we have a heavy workload. And KISII, given the density, or the population density, we of course have a lot of cases related to land disputes and other disputes that arise from land. We are rolling out a program called the Alternative Justice System Program here in KISII. We want to roll it out in the month of February or March. This is a program where we have wazes, please use the word wazes, in the village who are capable of determining some of these disputes, especially those related to land, because it is within the society and within the village that the elders know a lot about the history of land, who may be the rightful owner, if somebody has moved the boundaries where the boundaries really were, and also conflicts within family. So would encourage the people in the village who may have such disputes to touch base with the alternative justice system. We want to roll it out with the assistance of the KISII Council of Elders, and we feel that they are adequately equipped to take charge of some of these disputes that can be resolved at that village level. And as judiciary, even in case the disputes don't get resolved at that level, we are here as an institution. We'll hear those cases and we'll make determinations as is our mandate to do so. Thank you very much.